business owners. It's Deanne Chase, founder of Chase Law Group, here with our employment law specialist, Scott Liner. And today we're going to be talking about the new laws for 2024 that business owners need to be aware of. So, Scott, thanks for being with us today on Employers Corner.
Absolutely. Great to be here and great to share with everyone some of the new changes that are coming up effective January 1, 2024.
Yeah, well, there are a lot of laws that employers need to keep track of as a California employer, and it's getting harder and harder, kind of to keep track of these things. And that's why I'm so glad to have you part of our firm, and you are an amazing resource. And so why don't you just kind of high level let us know about the top 5 say, and there are a lot of new laws, right? And a lot of laws that apply anyway, but top 5 laws for 2024 that business owners need to be aware of.
Sure. Well, big overview. The big changes are the increase in paid sick leave, as well as a new change and a new addition to leave, which is a reproductive loss leave, which applies to employers with 5 or more employees. There's also a new prohibition of testing for cannabis, and we'll get into that issue in further detail. We'll also talk about the new prohibition or added prohibition in laws on non-compete and non-compete agreements in California. And lastly, we'll talk about some of the increases in minimum wage.
Okay, great. So let's talk about the paid sick leave. What's new for 2024?
Employers are required to provide 3 days of paid sick leave. That's been increased now to 5 days under the new law. And so other than that additional 2 days addition, so now we go from 24 hours a year to 40 hours a year, there's also an increase in the amount that employees can accrue annually. So it went from 48 per year to now up to 80 hours per year. Now, employers can do one of 2 things when they do this. They can either front load all the time at the beginning of the year, and this is easiest to do because you don't have to accrue and account for the time as they go along. Otherwise, you have to, or employees are enabled to or have a right to accrue up to 1 hour for every 30 hours worked. There's also an alternative accrual method that they can use, which is as long as they have at least 3 days by the 120th day of their work, and then the remaining 2 days by the 200th day of work, that can still apply, but you start getting into the weeds of this, and I prefer to keep it simple if at all possible. Some of the other things that still remain in effect is employees aren't entitled to the paid sick leave until they've at least worked 90 days with the organization. So in some ways, not a lot of changes other than the 2 additional days and the increase in accrual. The other piece that I'll remind people about is that they must reflect in the pay stub or in an additional writing that's issued at the time of the pay stub is issued, the amount of available accrued leave that the employee has each pay stub. So again, there's some accounting that has to be done along the way.
Great. Yeah, definitely. It's a lot to keep track of. And, kind of related to that, right, is that if the employer has an employee handbook that covers these things, is that something that they might need to update?
Yeah, this is a perfect time to take a look at their employee handbook, and in particular, this change is something they should for sure do, is again, increase that to 5 days and make sure that their existing policy complies with all their aspects of California law.
Okay. All right, great. And just kind of a quick question on it, kind of related, is unpaid time off. Is it beneficial for the employer to keep the paid sick leave separate from that PTO policy?
The only reason you would really want to keep it separate is that at the time of separation, employees are entitled to all PTO paid out, whereas sick leave, if it's kept separate, the employee is not entitled to that payout. So it's a decision. I see employers approaching it both ways, just depends upon their preference.
Okay. All right, fair enough. So reproductive loss leave is a new law coming into effect 2024. Tell us what employers need to know about that.
Right. So this is going to provide, and it only applies to employers with 5 or more employees, but it's going to provide up to 5 days of unpaid leave per event. And an event is defined as either a final day of a failed adoption, a failed surrogacy, a miscarriage, a stillbirth, or any unsuccessful assisted reproduction. And then employees are entitled up to 20 days total for the year, so 5 days per year. This is unpaid leave, but employees, if they have existing vacation or sick pay, they can use that leave under those circumstances. So something else for employers with 5 or more employees to add to their employee handbook and policies.
Got it. Okay. Yeah, that is new. Cannabis. So,
Yeah.
it used to be in the old days, right? Where I remember I was talking to someone recently about I used to work for a summer in a can factory, American National Can, and they did drug testing right before they hired us. And of course, if you had marijuana that came up, not that I would, but if they had marijuana that would show up in the testing pre-employment, that was something of concern. So with cannabis being, the legality of it and all that, what is the change for 2024 when it comes to cannabis?
Yeah, so this is a law that was actually passed over a year ago, but they delayed the implementation of it until January 1 of 2024. And the big change is now that testing can only be for cannabis only. It can't test for THC, the psychoactive part of marijuana ingestion. So because of that, employers can't test applicants or employees. However, if there are, and there will be new testing, the focus of this law was to change the type or ask for different types of testing. There is some other kind of testing out there, saliva testing, et cetera, that you need to talk to a specialist about and what's available out there for that. But there's a testing that would only apply to THC, but you can't just test generally for marijuana use. Now, you still can take adverse action and do an investigation if someone's seemingly impaired by the drugs or something, and you can still approach them on a behavioral standpoint. You just can't test them. There are some exceptions to this law, including the construction industry, as well as any other industry specific or jobs that involve either federal or state regulations, which could include, for example, like working in hospitals.
Okay. All right. Good to know. Let's talk about non-competition provisions. So,
Sure.
of course, we know generally speaking, in the state of California, non-competition provisions are frowned upon, shall we say, in the state of California. Can you tell us a little bit about kind of what the current state of the law is, and then how it changes in 2024 with regard to non-competition provisions?
Sure. So the existing law under Business and Profession Code section 16600 already made non-compete agreements unenforceable in California with limited exceptions, such as when there's a sale of a business of something more than a nominal piece of the business. So the legislature felt, though, however, that employers were still using non-competes as a deterrent out there. So the new law basically just says, hey, these agreements are void, and employers cannot even enter into them with their employees. And there's penalties associated with that and damages that employees can assert if that's required. Also, they even went a step further, which requires notification of any employees, current employees, as well as former employees who were employed from January 1, 2022 forward. Notification needs to be provided that any non-compete that was entered into with those employees or former employees are in fact void. So taking a very strong position toward non-competes. And then the final piece of it is even if it was an out-of-state employer, unrelated to any California employer, who entered into a non-compete with one of their out-of-state employees, and that employee came to California, California is not going to enforce that non-compete between that non-resident employee or employer here in the state of California. So the legislature and the governor put their foot down and made it very clear that non-competes, except for limited circumstances, are unenforceable. That being said, employers can still protect their trade secrets. Employees can't use their trade secrets, regardless of whether it's in competition or not, but it no longer has to be tied to any competition issues. Just if employees are wrongly using trade secrets, that can be attacked on a standalone basis.
Got it. So as long as the employee is located in the state of California, even if the employer is not, that employer still has an obligation to advise a former employee that their non-compete is void.
No, we're not going to require out-of-state employers to notify the employees here. That piece of law is just saying that agreement won't be enforceable here in California. The notification requirements is only going to apply to resident California employers who have entered into any non-competes with their employees. So it's important that those listening look to see if they have any non-competes with their existing employees or any that they entered into after or beginning in January 2022.
So they only need to, so that just to be clear, the employers only need to go back to any employees January 2022 to present?
For former employees. For all employees of their current, if they have a non-compete, they need to send out the notification that the agreement is void.
Got it. Okay, that's tricky because I know a lot of business owners are, of course, concerned about making sure that someone leaves, they're not going to steal their clients or their business, but that's where the trade secret protection comes into play.
Correct.
Yeah. Okay. Let's talk about the increase in minimum wage.
Sure.
What are we looking at for 2024?
So for the state of California, we're up to $16 an hour for all employers, regardless of size. But remember that some municipalities may require more. In fact, Los Angeles and unincorporated areas are up to a higher amount. It's approximately 16. The Los Angeles requirement is up to $16.78, and the unincorporated areas of Los Angeles County are to $16.90. Both of these rates will remain in effect until July 1, 2024. So just be aware if any of your employees are doing work more than 2 hours in any week in the city of Los Angeles or the unincorporated areas of Los Angeles County, then they'll have to be paid that additional increased amount. Also be aware that related to that California minimum wage rate of $16, that increases the minimum salary for exempt employees to $66,560. So if you have exempt employees, you need to make sure that you're complying with that moving forward. And then finally, beginning January 2024, all healthcare workers, with few exceptions, will be entitled to a minimum wage of $25 per hour, and also fast food workers will be entitled to $20 an hour. So a lot of changes going on in the minimum wage world.
What was the minimum for healthcare?
Healthcare is $25 per hour.
Oh, 25. Okay. All right. And so, and we're talking about when you're talking about the these cities that might have different wage requirements, that is where the employee is physically working, right? It doesn't make a difference as far as where the employer is headquartered. It's where the employee is physically located. Is that right?
Exactly. And that comes in, for example, if you have remote workers, you need to know where they're working remotely from their home. Where do they live? That's the law that's going to apply. That's the minimum wage, I should say, that's going to apply.
Great. So what do you recommend as far as employers go with regard to their employee handbook and how frequently they should be reviewing it and updating it?
Well, certainly every year they should be taking a look, and we provide a newsletter around this time of year that lets folks know what the changes are in employment law in California. So every year they should be looking for changes, and I'll let them know through our newsletter what changes are coming up. And then with these new changes that apply this year, they should reach out and have their employee handbook updated to make sure they're in compliance with the California new laws.
Great. Well, thank you so much for being here today on Employers Corner. And we will be back with more key information that employers need to know. Thank you.
Great. Thanks.